seated. So, good afternoon. We are here in re Structurlam Mass Timber US Inc., which is case number 23-10497. And let me pass the baton to counsel to the debtor to take us through our agenda.
Thank you, Your Honor. For the record, William Chipman, Brown, Cicero, and Cole, proposed counsel for the debtors. First, I want to thank Your Honor for making time for us this afternoon to consider the debtors' bidding procedures. Before we get started, I thought I'd make a few introductions since the last hearing was virtual. Your Honor, we have in the courtroom today Mr. Kevin Haggard from Miller Buckfire, who's the debtors' investment banker. And we have Mr. Matthew Cornell, the debtors' interim CEO.
Welcome.
Your Honor, we were hopeful and worked hard to be here today on a fully consensual basis. However, there were a few limited objections still unresolved. And I think they relate to the timing, Your Honor, and the bid protections is basically what we're focused on today. We did file a reply to the limited objections, a revised form of order and bidding procedures that we believe resolves many of the issues that were raised by the United States trustee in the committee. I hope Your Honor received these and has had time to review them for today.
So I have, just so that we're all rowing together, I take it the U.S. trustees' objections were informal, so to the extent those are worked out, that's invisible to me, is that right?
Correct, Your Honor.
Got it, okay, then we're all together.
Okay, thank you. Your Honor, the bidding procedures and sale timeline have been carefully tailored to maximize value of the sale and marketing process. The debtors and their management began the sale process planning several months before the bankruptcy. As part of this process, the debtors interviewed numerous investment bankers, ranging from small to large shops, and ultimately engaged Miller Buckfire, an investment banker with deep relationships in the mass timber product industry. Immediately upon their engagement in early February, Miller Buckfire launched a broad-based marketing effort, contacting both strategic buyers, those with experience in the sector, and financial buyers and investors. Though time was of the essence, given the company's liquidity position, the debtors, their management, and advisors carefully crafted the marketing and sale process with the goal of securing one or more stalking horse bidders for the company's assets prior to any bankruptcy filing, either on a standalone basis or as a whole. In total, the pre-petition marketing process ran a full 70 days and resulted in the stalking horse bid from Mercer in the amount of $60 million. Your Honor, this is certainly not a situation where the marketing process began shortly before the bankruptcy filing. And since the petition date, the debtors' advisors have been hard at work continuing to run the marketing process. It will be 103 days from the start of the process through the proposed bid deadline. The debtors, in their business judgment, believe this is enough time to fully test the market and maximize value from the sale process while limiting unnecessary administrative expenses and costs to the estate of an extended post-petition marketing process. Not only do we believe a 100-plus day sale process is enough time, but it is also certainly within market practice for a company of this type in this court. Your Honor, under the Stalking Horse APA and the DIP financing, the debtors must obtain a sale order by the end of May. And there are good reasons for this. The purchaser is buying not only an operating plant in Canada, but also the U.S. plant that has been basically shut down and has no customers, or very few customers. In order to get that plant up and running and producing product, the purchaser is looking at a 6 to 9 month lead time. Among other things, they're going to need to hire employees, solicit customers, design product for specific projects, purchase raw materials, and begin to produce the product. However, we understand that Mercer has potential production capacity it can send to the U.S. facility now that will allow the restart of production in the near term. This means hiring employees, paying vendors, and servicing contracts. However, in the event the sale timeline is extended, we understand that Mercer will be forced to subcontract out that work to another facility to meet its own production deadlines. It is our understanding that obtaining a sale order by the end of May is critical to the Stalking Horse's business plans and is the reason why they offered $60 million.
So, Mr. Chipman, what you just said, I've read the declarations.
Yep.
Is what you just said, I don't recall, I could have missed it, but is that in evidence as, well, nothing is in evidence yet, but,
Your Honor, it's not in evidence. This is my argument in support of the motion and
Oh.
and in support of the May 30th.
all right, is the evidence going to show that?
We're hoping that counsel for Mercer may be on the phone.
Hearing from counsel isn't evidence.
I understand, Your Honor. We're just trying to give you some background why we think it's necessary.
All right, but if the background you want to give me is factual, it has to be in evidence or I can't hear it.
Okay. Your Honor, I'll move on.
Okay.
Your Honor, with regard to the bidding procedure, it's most important to note that the most likely bidders and were, as of the petition date, already well aware that the debtor's assets are for sale, and most likely have already been contacted during the pre-petition marketing process. In connection with the formal marketing process, as described in the Haggard Declaration, the debtors and Miller Buckfire undertook extensive efforts to identify and reach out to potential buyers interested in a sale transaction with the debtors. Given this outreach, it was well known in the industry among both potential strategic and financial buyers that the company was open to a potential sale of the debtor's assets. These efforts have continued uninterrupted following the petition date. Accordingly, we believe there are valid business reasons for the currently proposed post-petition timeline that will benefit the creditors of the estate. With respect to the stalking horse protections, these protections were the result of good faith negotiations between and among the company, the stalking horse purchaser, and the senior secured lender. We believe the protections are well within market. The breakup fee is 3% of the total cash consideration. The expense reimbursement requires reasonable and documented backup, and the bid increment of $500,000 is less than 1% of the purchase price.
Can I stop you there for a second?
Sure.
When you say that the expense reimbursements have to be reasonable, is it clear from the order you're asking me to sign that that's the case?
Your Honor, I thought it was. But
Okay.
my understanding is that in order to obtain expense reimbursement, they have to document the expenses, and the debtors get a chance to review that before they get paid.
Okay.
If it's not in the order, honestly.
Okay, so there's no disagreement that the expenses need to be actual and reasonable?
My understanding is there's no disagreement.
Okay, that's helpful. Thank you, Mr. Chapman.
Yeah. These bid protections were necessary to secure the stalking horse bid that covers the pre-petition secured debt while not shilling bidding for the sale process. These stalking horse protections were agreed to in the context of the stalking horse bidder materially increasing its bid from its initial indication of interest. As the court is aware from the first day declaration and from our prior hearing, this case is on a fast track and presents a matter of urgency for the company to achieve a value maximizing sale. In this case, we have a stalking horse that is willing to close a transaction subject to higher and better offers and this court's approval in a short period of time. Finally, Your Honor, the debtors and their advisors are unaware of any potential purchaser requesting more time to formulate their bid or that have complained about the process. While we understand the committee and Walmart wanting more time, the debtors need to balance that with the risk of losing the stalking horse given the fulsome 100-day plus process that is being run. Your Honor, if I could turn to the pre-petition marketing process in a little more detail.
Certainly.
Miller Buckfire began the marketing process by identifying and contacting a broad group of potential strategic buyers and financial sponsors for both sale and financing options. This process also included all potential strategic buyers focused on or interested in expanding into the mass timber product industry, including glue laminated beams and cross-laminated timber. 74 prospective buyers were solicited, of which 36 executed non-disclosure agreements, and 18 prospective investors were solicited, of which 7 executed non-disclosure agreements. The parties that executed non-disclosure agreements received access to the company's virtual data room and were offered management meetings and site visits. At that stage, 3 parties conducted site visits and 5 parties conducted meetings with company management. By March 8th, 2023, 5 parties provided non-binding indications of interest. These 5 parties were provided with access to additional diligence in the data room, continued access to company management, site visits, and a draft asset purchase agreement. Miller Buckfire requested binding bids from these 5 parties by March 24th, 2023. Ultimately, the debtors received 3 non-binding bids. Following the receipt of the initial non-binding bids, the company and its advisors worked with initial bidders to evaluate, solidify, and improve the initial bids received. Ultimately, after such evaluation and analysis, the bid by the stalking horse purchaser was determined as the highest or otherwise best initial offer, and the company and its advisors engaged with the stalking horse purchaser concerning the terms of a purchase agreement. On April 21st, 2023, the debtors and the stalking horse purchaser entered into the stalking horse purchase agreement, and the debtors filed these cases. The bidding procedures are designed to promote a competitive, fair, and efficient sale process that seeks to maximize the value of the debtors' estates. If approved, the bidding procedures will allow the debtors to solicit and identify bids from potential buyers that constitute the highest or otherwise best offer for the assets on a schedule consistent with the milestones set forth in the stalking horse agreement and the DIP facility. Your Honor, turning briefly to the stalking horse protections. As the court is aware from the motion, as part of the bidding procedures, the debtors request authority to, among other things, provide the stalking horse purchaser a reimbursement of the stalking horse purchaser's reasonable and documented expenses in an amount up to $600,000 and a breakup fee in the amount of $1.8 million. The expense reimbursement and the breakup fee, which represent 1% and 3% respectively of the cash purchase price, not including substantial assumed liabilities, Your Honor, are market and well below the high end of the range of bid protections often allowed in this district for Section 363 sale processes. Your Honor, we cited to numerous cases where similar amounts were approved in our reply. Furthermore, the stalking horse protections are reasonable in light of the stalking horse purchaser's considerable efforts in setting a floor for the auction of the assets. We also believe the proposed bid increments are also well within market as set forth in our reply. And they're set, Your Honor, at $500,000, which is less than 1% of the purchase price. Your Honor, turning to, there's 2 limited objections. And as set forth in our reply, Walmart and the committee basically request an extension of the overall timeline of the sale process. Obviously, Your Honor, my argument is against that for the reasons I've stated. However, as just discussed, the limited objections are not aligned with the realities of these Chapter 11 cases. The fulsome pre-petition marketing process already being run and the need to ensure the continued support of the stalking horse purchaser, without which the value of the debtor's estates could be jeopardized, is critical. Similarly, with respect to the limited objections argument related to stalking horse protections, such objections should be overruled as the stalking horse protections are consistent with similar protections approved in other large Chapter 11 cases. Your Honor, in support of the bidding procedures motion, the debtors would like to offer into evidence the declaration of Kevin Haggard of Miller Buck Fire in support of the debtors' bidding procedures motion and motion to shorten notice regarding bidding procedures motion filed at docket number 19 regarding the sale process. And I also have another declaration, but I'll let Your Honor.
Okay. Is there any objection to the introduction into evidence of Mr. Haggard's declaration at DI 19? Okay. Seeing none, that will be admitted. And let me ask, does anyone intend to cross-examine Mr. Haggard? Okay. You can continue.
Thank you, Your Honor. Your Honor, the other declaration we'd like to offer into evidence in support is the declaration of Matthew Carmel, the interim chief executive officer of the debtors in support of the debtors' Chapter 11 petitions and first day motions. That's at docket number 9. And that's just basically for general background information about the debtors in these cases.
Got it. That was just the first day declaration?
Yes.
Got it. Okay. Is there any objection to the admission into evidence of Mr. Carmel's first day declaration at DI 9? Okay. Seeing none, that will be admitted. Any cross-examination? Okay. If not, Mr. Chipman, you can proceed.
Thank you, Your Honor. Your Honor, unless Your Honor has any questions, I know that the counsel for the committee and maybe counsel for Walmart maybe want to talk about their objections. Unless Your Honor has any questions, that's it from the debtors.
Okay, so I don't have questions. I'll come back to you, but let me give the objectors the opportunity to be heard, and then I'll reserve the right to bother you after I hear from them.
Thank you, Your Honor.
Okay, thank you. I know reservations of right are generally disfavored in this court, except when they come from me, in which case the rules are totally different.
Good afternoon, Your Honor. Julian Gurley of Buckhalter for the Official Creditors Committee in this case, Your Honor.
Yes.
Thank you. My co-counsel is Matt Harvey of the Morris Nichols firm. Thank you, Your Honor, first of all, for entering my pro hac vice application this morning. It's really a pleasure to be here in person after a number of years. So.
Well, welcome back to Wilmington.
Thank you. Thank you. And I would also like to thank Your Honor for Your Honor and the debtor's accommodation, given that the committee was just recently appointed to give us the benefit of the second half of last week and the weekend to put together, among other things, a limited objection.
So I knew when we had the discussions at the first day that we were jamming you. I was persuaded that under the circumstances that was the appropriate thing to do. But that said, I do appreciate the burden it imposed on you and the committee itself, and appreciate your working with that. And to the extent you've got points to make beyond what you were able to put into your paper that you just got in, I want to give you that opportunity in light of the fact that you were jammed by me. So
I really appreciate that, Your Honor, and I'll accept those kinds of words on behalf of the committee members, who I'll describe to you in a moment, because they are really the volunteers here. Those of us who represent committees from time to time know timing is sometimes the nature of the beast, especially at the beginning of a case like this, but very appreciated, Your Honor. Your Honor, I think given the timing and the posture of this case and our limited objection, and it is a limited one, Your Honor, I'll be brief. Hopefully Your Honor had a chance to review our also brief limited objection today. I'd like to go through very briefly the three main points there. But just by way of background, Your Honor, you may have seen from the docket, of course, but the committee was originally appointed by the U.S. Trustee's Office on Wednesday, probably late in the afternoon on Wednesday, originally with 2 members. The original 2 members were Tecum Tech USA Inc. and Simpson Strong Tie Canada Limited. We were originally going to proceed with just 2 members. Mr. Hackman was able to find us a third, which is much appreciated and gives us we're going to, as much as possible, work by consensus, but it does not present a tie-breaking issue, Your Honor. And our newest member, who joined us just on Friday, Your Honor, is Broadhead Operating, doing business as H&H Agency, Your Honor. These are all 3 vendors, Your Honor, trade vendors. They're sophisticated business people. They're looking to, through volunteering their time, try to improve the case and be a constructive participant in these cases. Your Honor, that is really our mandate, is to be here, to be working with the debtors wherever we can on the sale process and looking forward on financing issues, wind down issues, and the rest, always with a constructive eye to try to add value. We're not looking for disputes, and hopefully, Your Honor, for the debtors and their advisors, and Your Honor, seeing in our papers, we're trying to limit the issues to just what we think are the bigger picture points. Immediately in front of us, Your Honor, for the last 4 days has been the sale procedures. The committee, I should also note, interviewed and hired Dundon Advisors as their financial advisor. Dundon has been retained since Friday and has been working through the weekend to try to get up to speed, including speaking with the team at Northblock Fire. Your Honor, the committee's overall view is that the debtors have done a good job of bringing us to this point. At this point, I know there was a lot of effort expended pre-petition, and securing a $60 million stalking horse bid under these circumstances, and with the secured debt level at the level it is, $60 million is what we think of as a good start, Your Honor. It's a good place to be, but turning to where we go from here, we want to make sure that in signing up that stalking horse bid, we don't foreclose the potential for a very competitive and hopefully very active and very well attended auction process, whether it's in 3 or 4 or 5 weeks from now, Your Honor. And we think, given where the secured debt level is, the amount of unsecured claims, and hopefully what will be a limited amount of administrative claims, that there's a real potential here for a general unsecured creditor recovery. So we're to put it one way, Your Honor, we're really playing, we think, with unsecured creditor money.
So, so Mr. Grove, look, the way I think about this, all right, I started on the presumption that your constituency is likely the Fulcrum Security.
Yes, Your Honor.
And so your views matter.
It's nice to hear that. Some places that's not.
Well,
not the
you're
case.
not always, the
Yes.
economics aren't always the way they are
Yes.
here. That said, we also have the reality of the debtor who's exercised its business judgment and, a secured creditor that's willing to fund what it says it's willing to fund. That doesn't give it the right to dictate what happens in our court, but it's a consideration. So I guess, look, I've seen your papers. Let me ask this first. Is there any evidence that you want to present so the record is what I've got in front of me?
The record is closed.
Okay.
Yes.
So look, I am interested in hearing from you sort of as concretely as you can, what reason you have to believe that more time is helpful in light of the pre-petition marketing that took place. And what other, as to the breakup fee, the expense reimbursement, and the bid increments, what reason you have to take issue with the exercise of the business judgment that the debtors have given? Those are the questions that I've got.
Yes,
So,
and Your Honor, I think those are precisely the right questions to ask. And as committee counsel in this case, the business judgment rule is an aircraft carrier in a case like this. It has a lot of momentum. And so I would observe, Your Honor, for purposes of, let's turn first to the timeline, Your Honor. And this is, if you'll indulge me, Your Honor, I don't have evidence because I had 4 days.
I understand that.
Yes. So this will just be argument and observations based on experience in cases like
Yeah,
this.
look, and I do think common sense can go a long way here. So I'm not kidding about wanting to hear what you have to say.
Right, and like we've told in what I think have been very constructive, open conversations with debtors counsel, and I understand that Dundon and Miller Buckfire have also spoken, as I said, I believe in our papers. We're in the data room, and that is all moving apace. Your Honor, 2 extra weeks is the request. The reason for 2 extra weeks, Your Honor, is, in my understanding, as counsel, right, less so to ferret out additional bidders. We think that the Miller Buckfire process has been well done, that the universe is the appropriate universe. In Dundon's sort of initial look at the list of contacted parties, who signed NDAs, who was active in data room and the like. The focus for us much more is, now that we have this universe of active participants, are we making sure that they all have sufficient time and a level playing field vis-a-vis the stalking horse to make sure that they can come up with the highest and best bids possible for themselves based on the information that they've been able to gain so far. And importantly, Your Honor, and hopefully Walmart's counsel is also on the line today, who's also a limited objector. Walmart is a central piece, obviously, of what this sale transaction is going to look like. I'm not in the heads of Mercer or the particular bidders. It would seem to me, Your Honor, to borrow your phrase, common sense would inform us, based on the history of this company and just sort of normal business sense, that having some sort of understanding with Walmart about what a go-forward relationship would look like for this plant that was constructed in Arkansas to service the Walmart headquarters would be helpful. And I can't say, Your Honor, that can't be done on this timeline for bidders other than Mercer, but my concern is that it could not, and that would have a chilling effect on bidding. That's, Your Honor, respectfully, my sort of 4-day interface answer on timeline.
And what they say, again, without evidence, but again, let's take the common sense of it, that that there's a buyer who, to the extent the sale gets delayed and they can take possession later, that reduces the value available to them and therefore puts this at risk. And as the representative of the Fulcrum Security, your view is that you would take that risk to the $60 million in order to get the advantage of an additional week or 2 weeks or 3 weeks.
Our view, Your Honor, is that the level of interest that we've been informed exists is that a reasonable amount of time, or whether it's 2 weeks, 1 week, 10 days, would
You think that would be
probably not
beneficial?
dissuade the purchaser from.
You think that the upside of giving other bidders the opportunity to poke around and to finalize arrangements
Right.
exceeds the risk of,
I mean, Your Honor, I absolutely get the point, and respectfully, I mean, that is why the business judgment rule exists, right? They get to make the tough calls, and I get to question them about it.
I understand, and then I've got to, then it comes to me and I've got to figure out what to do about it.
Yes,
So, let me ask you this. So look, from 40,000 feet, here's my and this is to all parties. The timing strikes me as, in the absence of a melting ice cube situation, a touch faster than is customary and is typical in this court. And the other items of consideration, the combination of the breakup fee, the expense reimbursement, and the bid increments, all strike me as essentially being on the line as the far end of what could be approved as reasonable here. And the case that I'm open to hearing is that all in, it leads to a process that is unduly skewed towards the stalking horse bidder and skewed against a value maximizing sale. I'm not saying I've decided that, but I am persuadable by that, not by any one item, but sort of through the totality. And so my question to you is, in a world in which you're not going to get everything, if you could fix one part of it, what part would you fix? If I were persuaded that the totality is too much.
Absolutely.
Does that question make sense?
Yes, absolutely, Your Honor. And I don't even know if these would qualify as settlement negotiation. We don't have a dispute with the purchaser, but an idea, let's say, would be we get the timeline and they're compensated for that with the bid protections at the level that they are currently proposed. That would be.
Okay, so as between trimming the bid protections or
We would
trimming the
rather
bid
have
increment.
more time and pay for that time by
By-
allowing the Mercer to have what they've negotiated for in the purchase agreement.
Okay. And look, I'm here to resolve a dispute, not to broker a deal. So, but I am interested in hearing, on your wish list,
Yes.
what part is most important, and you're saying some additional time.
Yes.
Okay. Anything else that I should hear and
The
understand?
only point, Your Honor, that I would raise, not a point of argument, reservation of rights, Your Honor, that there are things that, of course, are going to be sale issues, hopefully we.
Oh, we're only here talking about procedures.
that's
So,
all.
yeah, yes, to the extent you've got an issue with the sale order, we'll hear that when the time comes, and by not saying it now, you haven't waived anything.
Absolutely. Thank you, Your Honor.
Okay, thank you. Yes, certainly.
Judge James Sullivan, on behalf of Bank of Montreal.
Yep.
I just wanted, for the record, to state that Bank of Montreal is on board with the revised proposed order that the debtor has put forward. It gives additional time that the committee is seeking, and also is within the DIP budget, which is not going to fund operations beyond May 31st, or actually May 30th. So those things all line up. Again, it's a good compromise. I thought the parties worked very hard just to get there. And Bank of Montreal would agree with the debtor's proposed revised order.
Okay,
Thank you.
thank you. Mr. Chipman, unless there's is there anyone else that would like the opportunity to be heard in opposition to the proposed bid protections? I see Mr. Newman, I see you're on the Zoom. Would you like to be heard?
Yes, Your Honor. Ari Newman of Greenberg Traurig on behalf of Walmart. I'm here with my co-counsel, Dennis Maloro, who's based in Delaware, as I'm sure Your Honor knows. Your Honor, don't want to belabor points that have already been made. We rise in support of the committee and the common sense concerns raised. Your Honor, if we could have our cake and eat it too, we'd ask the debtors just to extend the timeline modestly. And again, as raised in the papers, this wasn't a case where the committee and or Walmart came or a creditor came in and sought an additional 60 or 90 days. It was just a very short additional extension that we're looking for here to ensure that value is being maximized. There's no interest here in jamming the debtors, the lender, or the buyer. But the short additional time being requested would give comfort to the general unsecured creditors, particularly to Walmart, at little cost to the buyer and the debtors that the process was value maximizing. And so with that, Your Honor, and of course the other component is just to trim the bid protections a little. So we think there could be a give on both sides and everybody can prevail here.
Okay, thank you, Mr. Newman. Mr. Chipman.
Yes, Your Honor, a couple points. I want to note that active bidders have been under NDAs in this case since February, March timeframe. These are bidders that are actively or truly active that are most likely to be part of the process. Your Honor, also extending the timeline, as Your Honor is aware from our papers, it increases uncertainty for the debtor's current customers. We have other customers in Canada that also want to see this get done. And Your Honor, in case Your Honor has any questions at all about the process, Mr. Haggard is in the courtroom and he's happy to get on the stand and answer any questions Your Honor may have about why it's important to keep the May 30th date.
Actually, I think that would be helpful.
All right.
Why don't we call Mr. Haggard? Swear the witness, please.
Hi, can you raise your right hand? Do you affirm that you will tell the truth, the whole truth, and nothing but the truth to the best of your knowledge and ability?
Yes, I do.
Please state your full name and spell your last name for the record.
Kevin Haggard, Haggard.
Thank you. You may be seated.
Thank you.
So obviously, if you would like to present the witness, yours in the first instance. I have a couple of questions, though, in the absence of the parties.
Your Honor, I'll just generally ask Mr. Haggard to explain to the court why we need to have the bid deadline stay on May 30th.
Good afternoon, Your Honor. In my mind, there's three simple reasons for that. One, the length of the process that we've run will have been over 100 days. Market is certainly within that time frame. We feel we've exposed the assets very broadly to a number of parties, and as Mr. Chipman indicated, those parties that are active have been involved since February, and a couple of them since March, but February, March, they've been involved for a long time. Number two, we do have genuine concerns about the stalking horse bidder and their ability to terminate at the end of the month. They have business operations to fulfill. They'd like to do it at this plant, but they will and are considering doing it in other manners to ensure that they can fulfill their customer orders. And then three, we are concerned, or our company is concerned about our existing customers in Canada. Their concern about the overall process and the ability for these operations to continue is acute, and their concern will lead to potential erosion of our business the longer this goes.
Okay.
Your Honor, I'll turn the witness over to Your Honor.
Okay. So Mr. Haggard, let me ask you the question this way. Simply from, imagine you didn't have pressure from the lender about the time they're willing to finance, and you had enough resources there to run this process the way you want to run it. And in light, and then everything else being exactly the same, right? We ran the pre-petition process the way you have. Would it be, in your judgment, from the pure perspective of value maximization, would it be better or worse to have another week before the auction?
In my judgment, I think it would be worse. marginally worse because of the customer concern I raised and because of the incremental expenses, professional fees, et cetera, that'll be run up during that time period.
And what's your response to the point that Mr. Gruhl made during his argument about the benefits that would come in terms of working with other potential buyers on a successful transition? Like, explain to me why the concerns you identify outweigh those concerns.
I believe it's certainly a reasonable argument to make under other circumstances. Under these circumstances, those that are active have been active for a long time. They're very familiar with our process and our timeline. We keep an active dialogue. They know they need to get their work completed in the time we're asking for, and they've been involved for a long time. So I don't view that incremental time as giving, getting to, great, now we have an extra bidder at the auction. I think it's just like everything else in life, the extent you have more time, people will use it, certainly, but I don't believe that they will sort of need it to get to a bid.
Okay, thank you. That's helpful. Obviously, now that I ask questions, to the extent anyone else would like to question the witness based on any of that, you're welcome to. Okay, seeing none, thank you for your testimony.
Thank you, Your Honor.
Thank you, Matt.
Okay, any further argument?
Your Honor, no. I think the debtors rest, and again, we respectfully request that Your Honor enter the bidding procedures order.
Okay,
Thank you.
thank you, Mr. Chairman. Mr. Gruhl, let me ask you this question. In light of the testimony you just heard from, a witness who's on the ground and with actual business expertise, who says there's good reason why faster here is better than longer, and in the absence of any contrary evidence, why? Look, I hear the instinct, and to be, as I said, my own experience and my sense of what is customary in this court is that this is faster than one would typically proceed, even with an extensive pre-bankruptcy process. But I now have, and look, I understand that putting you to an evidentiary test 48 hours after your client came into being isn't totally fair. But you did have the opportunity to cross-examine the witness. So what I've got now is unrebutted testimony that says this is value maximization, from the perspective of value maximization, this is better. So what reason do I have to not defer to that record testimony?
Right. Well, I think at the end of the day, Your Honor, and in other roles, I rely heavily on the business judgment rule that exists. Right? That's the law that we're living under. That's the standard. And that was admitted testimony. And as much as maybe in the next life I'd like to come back as an investment banker, I'm not one today. I'm just a bankruptcy lawyer. My gut tells me that that this amount of time with this purchaser under these circumstances, 10 days, 2 weeks, the line will hold and we could get the benefit of that process. But Your Honor, I do not have, as you said, 2 business days worked in this case, contrary evidence.
Okay.
Respectfully.
No, I appreciate the unfairness to holding you to that. That said, we have the process we have, okay, I appreciate your candor. Thank you very much.
Thank you.
Okay, look, here's where I am. I think this is a close call, because I do think at a gut level, having a period as short as this between the bid procedures order and the auction, in the absence of a melting ice cube situation, is unusual. And while I, Mr. Sullivan, appreciate the lender's perspective, I tend not to take the dictate of one party as a genuine external limitation that is a basis to impose a deadline. Because if we did, then we'd be completely at the direction of parties who want the benefit of the process, and that seems to me not what our process contemplates. So I took the bench thinking that the time was a little bit too short, and that coupled with bid protections and bid increments that were on the outer limit, that it made sense for something to give. Actually, let me come back. No, look. Whether the bid increment should be $500,000 or some amount like 250 to me is not. I'm not inclined to micromanage the process that way. I do worry. I still worry that all of these things in the aggregate feel to me to be on the outer limit of what's appropriate. But the real issue is the time. And on the question of the time, I've got sort of unrebutted testimony that I incline to credit, that it's the debtor's legitimate business judgment that independent of the external deadlines being imposed by the lenders, that they think this timeline is the value maximizing timeline. And you know, if we had, you know, a different banker saying my judgment is different, I don't know where I'd be, because I have concerns about this being shorter than is customary. So I have qualms about where we are, but I also don't think that I'm here with a blue pencil to design the process the way I would design it. I think the question in front of me is, have the debtors, you know, exercised reasonable business judgment and supported it with evidence that supports the exercise of judgment. And under these circumstances, I will, with some reservation and trepidation, enter the order as approved. I'm satisfied that that the record supports the relief, and that notwithstanding my qualms and reservations, I think that that this is approvable, and that if any of you cites this order in an opinion and against, you know, to me, you do so at your peril. So with that, I will enter the order. Mr. Chairman, anything else that we can do?
Thank you, Your Honor. Understand Your Honor's ruling. Thank you very much. That's all the debtor has today.
Okay. Is there any way the court can be helpful to any of the other parties in interest? Okay. If not, thank you. Appreciate the argument and the evidence. And with that, we're adjourned. Thank you.
Thank you, Your Honor.